So, Detective Paulos, where we ended off, we were talking about the necessity to bag people's hands, right?
Yes, sir.
And potentially what bagging people's hands can reveal, right?
Correct.
And I think we'd moved on from potential DNA under the fingernails to potential evidence regarding the use of a firearm, right?
Correct.
All right. Now, you heard testimony from the state DNA analyst that things like DNA specifically, can stick around for a very long time. Things can be tested much later in time, and potential DNA can be discovered, right?
Yes, sir.
A lot of cold cases somehow are reopened because DNA evidence, right?
Correct.
But with things like firearms testing, that evidence is much less susceptible to maintaining over a period of time, right?
Correct.
Because what we're talking about are chemicals on the skin, maybe, right?
Yes, sir.
And so it's unlike DNA testing maybe in an orifice of the body or in the mouth or something like that, or in dried blood. Once a body is, say, either cremated or buried, then you lose the opportunity, do you not, for effective testing, or you certainly can, right?
You can, yes, sir.
Okay. And so in this case, we've already established, and you heard the testimony from the variety of testimony about the way firearms are discharged and how chemicals can be deposited on the hands, right?
That's correct.
And we've already established that in your line of work, in the world that we all operate in, there are tests to determine whether or not someone has fired a handgun, right?
Correct.
And those tests can be less than 100% dispositive, right? I mean, they're not 100% accurate, right?
I'm not sure I can.
Okay, but they're tests that are certainly available to you, right?
Correct.
And in this case, even though you might have found out a few days later that Tai Chan indicated that he'd been fired at first, right? That Jeremy Martin had shot a gun at him or fired a gun at him, right? You learned that.
I don't recall that.
You don't recall having learned that Tai Chan, in his recorded statement that we've listened to, said that Jeremy Martin fired a gun at him?
Yes, sir. Fired first? Yes, sir.
Yeah, you fired first, right. And so that would have at least given you some indication that something that needs to be checked out is whether or not Mr. Martin's guns were employed or whether he fired a gun, right?
That's correct.
Okay. And we know in this case that not only were Mr. Martin's guns never tested to see if they've been fired, Mr. Martin's hands were never tested for residue, gunpowder residue, paraffin, whatever it might be, to determine whether or not Jeremy Martin had fired a gun, right?
That is correct.
Okay. And unlike the DNA testing that was done yesterday on the bed sheet, there's not a way to go back and test Jeremy Martin's hands, is there?
No, sir.
No. And unlike the technology that allows us now to know that all of the blood on the bed belongs to Ty, there's never going to be a way to test to see if Jeremy Martin fired that pistol, right?
Correct.
And you know in our system, and because you're a detective, and you know both the law and the Constitution and the burden on the state, right?
Yes, sir.
The jury is left to ponder whether or not Jeremy Martin fired this pistol, right?
Correct.
And there was a test available to you that certainly could have been helpful both to the state and to the defendant, perhaps, at your disposal that wasn't completed, correct?
Yes, sir.
Okay. Okay, let me ask you about some phone calls. Are you familiar with Detective Torres's report, which gave the times and dates of certain phone calls?
Yes, sir.
You just looked at it, right?
Correct.
Okay. And tell me if you need your memory refreshed, and I can just hand you the report, okay?
Yes, sir.
So earlier today, Ms. Tafoya testified about having made some phone call communication between herself and Mr. Chan, right?
Yes.
And you know from kind of some call logs or some investigation done by your department the exact time and duration of those phone calls, do you not?
Yes.
And the first phone call she talked about, when she testified that she talked with Ty outside the hotel, you know what time that phone call was made, right?
Correct.
Okay. Do you know the exact time, or do I need to approach you and show it to you?
I believe it was, actually, I would have to be refreshed.
Sure. May I approach the witness, Judge?
Yes, go ahead.
11:56.
Okay. And you know that 1156 number not by some sort of guesswork, but through obtaining phone records and being able to look at the itemized call list, right?
That is correct.
And so there's no dispute about the first call being made between Leah Tafoya and Tai Chan at 1156, right?
Yes.
And you know that phone call was of a rather short duration, about 12 minutes, right?
Correct.
Okay. And then the second phone call between the two of them occurred at 12:10, right?
Yes, sir.
And that phone call was also very short. It was of a very short duration, right?
Yes, it was.
Okay. So we have 11:56, then again at 12:10, and then there was a third very long phone call, right?
Yes, sir.
And the third very long phone call took place at 12:13, right?
Correct.
And that was for a duration of 47 minutes, right?
Yes, sir.
And we know, based on 911 calls and based on reports of witnesses, that the duration of this phone call far exceeded the time of the shooting, right?
Yes.
And so when Ms. Tafoya talks about hearing the gunshots, right?
Yes.
You heard her testify about hearing the gunshots. We know that this phone call, that the line was open during the time that we know the shots to have taken place, right?
Yes, sir.
Okay. So there's no dispute, is there, about Ms. Tafoya's telephone, the line between Ms. Tafoya and Mr. Chan having been open during the time that the shooting took place, right?
No, there was not.
Okay. Okay, I'm going to show you what's been marked as defendants 56 or 58. Judge, there may be a problem beyond my control.
So can you be of assistance? Again, Mr. Clark, which exhibit is this?
This is defendants 58.
Defendants 58.
Yes, sir.
If I'm not mistaken, you utilized 45 through 62 yesterday.
Yeah, this is a previous exhibit that we.
It was already in.
It's 45 through 62. That would include 58. Your Honor. All right. So, do you recognize? Let me see if I can make this. All right. Do you recognize this? I'm lowered a little bit. Do you recognize this as the interior of the hotel room?
Yes, sir.
Okay. And I'm going to point. This is the armoire.
That's correct.
And there's a mirror that's depicted in several of the videos, the 360 videos.
Yes.
Okay. And then in the ceiling here, I'm pointing at what's been marked, a defect that's marked P, right?
Yes.
Okay. Now, one of the things that you have at your disposal, I believe, is the ability to determine or to attempt to determine trajectory, right?
Correct.
And there's reasons we police officers, investigators want to attempt to find out what the trajectory of a bullet is, or of the path of a bullet and a defect, right?
That's correct.
Because it gives you some idea, although it's not an exact science, it gives you some idea where the person who had the gun was standing, right?
Objection, Your Honor. Again, counsel is
Rules of evidence. What is the objection?
It's direct examination and counsel is leaving, Your Honor.
Sustained. Rephrase your question.
Is there a method by which your department can estimate or try to determine where a gun was standing or a gun was fired in relationship to a defect in a wall or a ceiling or the floor?
Yes.
Okay. And how do you do that?
I am not familiar with that. I have not done trajectories, but my department does do that.
And as lead detective, that would be one of the things I think that you could have asked for.
That's not me. completed, but phrase it.
And is that one of the things that you could have asked to have done in this case?
Yes, sir.
And was there, I guess there was a problem at the hotel with them patching some of these holes, right?
Correct.
But I'm also correct, am I not, that you knew where the hole was?
Objection. Please.
Again, there's been so much testimony about this. It only helps move the process along to allow some degree of leading. Someone give you some latitude. Again, in areas that haven't really been covered in previous testimony, don't need the witness, allow her to testify. Phrase your question.
Certainly.
Go ahead.
And what I'm getting to, officer, is that you had this tool at your disposal, or at least your department did, right?
Correct.
And in this case, like any other, the position of the parties can be of some relevance, can it not?
Correct.
And you'll agree with me that no attempt was made to estimate the trajectory of this defect, correct?
That is correct.
All right. Now I'm going to show you what's been marked as Defendant's 33. And I'm pointing at, this is that's the comforter or the cover that has now been tested, right?
Yes, sir.
Okay. And below this comforter, we see like a dust ruffle. I think that's the proper word for it.
Yes, sir.
Okay. Did you take that into evidence?
Yes, we did.
Okay. And it's was that submitted for testing?
It was not.
Are there any other items taken from the hotel room other than the sheet, red blanket, or the blanket, and the 2 pillowcases, all containing blood, that weren't tested?
That were not tested?
Yeah.
Not that I can recall.
Okay. Now, you heard testimony earlier about some comings and goings with Mr. Martin and Mr. Chan coming into the hotel, and there's been testimony by at least one hotel employee about Mr. Martin coming down looking for Mr. Chan. Remember that?
Yes, sir.
Okay, and your department, maybe not you, but your department was able to gather some video surveillance, correct?
Yes, they were.
Okay, and that was one of the things that you guys did early on, was try to get as much video surveillance footage as you could, right?
Correct.
For a variety of reasons, but in this case, it helps us determine specificity of times, right?
Correct.
Okay, and we talked earlier, and you were able to confirm some times where you're not on some video clips that I have?
Yes, I was.
Okay, and so when I asked you, and when we talked about, and when there was a testimony about Mr. Chan and Mr. Martin returning to the hotel, there's video footage that specifies that time, right?
Yes, it does.
Okay, and if I'm not mistaken, the time that we were able to confirm on the video was 11:43, right?
That is correct.
Okay, and there's no dispute. I think there's no dispute with your department that it was 11:43 that we see both of them walking into the hotel, correct?
Correct.
Okay, and then at 11:48, we looked on the same video. That there's video footage of Mr. Chan leaving the hotel and going outside, right?
Yes, sir.
Okay, and then at 11:48, we also have video footage of Mr. Martin approaching the front desk in a very brief video clip, right?
Yes.
And that's at 11:48 as well, right?
Yes.
Okay, and then we see video footage of, and it's again a very short clip, but video footage of Mr. Martin and Mr. Chan walking back into the hotel through the lobby at 12:06, right?
Yes.
Okay, and those times aren't in dispute, are they?
No, sir.
Okay. Also, there's some footage from the bank across the street that we looked at,
Yes, sir.
and in the bank parking lot and in the lanes, there were cameras that captured some at least potentially useful footage in this case.
Correct.
Okay, and based on those video cameras at the bank, I think the Bank of America across the street, we know that Mr. Chan was across the street by the bank, was captured on video footage. He was kind of running at 11:52.
Yes.
And then again at 12:01 and 12:02, we see Mr. Chan at the bank across the street from the hotel, right?
Yes.
And none of that footage contains any any interactions or offers any evidence about what might have happened in the hotel room, correct?
No, it does not.
But it gives us specific times if we're putting together a timeline about when people exited and entered the hotel, when people were outside the hotel and such, right?
Correct.
Okay, thank you. May I have a moment, Judge?
Yes, go ahead. Anything further?
No, sir. Pass the witness.
Mr. Byers, cross-examination of Ms. Detective Powers.
Let's get this perjury thing out of the way. You were the detective that presented the case before the grand jury, correct?
Yes.
I was the aide to the grand jury, is that right?
Yes.
There's nothing abnormal about that, is there?
No, sir.
Now, grand jury proceedings are secret, aren't they?
Yes.
Not asking you to divulge anything that happened in the grand jury, but asking you to describe the environment in which those proceedings happen. Things happen rather quickly, don't they?
Yes.
There's a schedule that's put out well in advance of cases to be presented before the grand jury, isn't that right?
Yes.
And the schedule is usually jam-packed, and detectives are lined up outside in the hallway. As a matter of fact, there's a grand jury going on today, isn't it?
Yes, sir.
It's Thursday, right?
Yes, sir.
Okay. Now, detectives don't have the luxury of just freewheeling answers inside the grand jury room, do they?
No, sir.
Basically, your function is to answer the questions that have been propounded to you. Is that right?
Yes, sir.
And is it fair to say that in response to this juror's question, I took that and modified it according to Mr. Clark's recitation of the transcript and proposed a question? Is that fair?
Yes.
Okay. Now, at the time, is it possible that many times a question can be asked, and if you're talking about the totality of the circumstances under which that question is asked, the understanding of that question may not come across, and then the detective gives a particularized answer. In other words, you testified today that the answer that you provided on that transcript was associated with whether or not the defendant had been issued his Miranda warning. Is that right?
Correct.
Okay. There are some things that are forbidden to be talked about to grand jurors inside that process, isn't it?
Yes, sir.
Okay. Sometimes Miranda warnings can fall under that, right?
Correct.
Okay. So, you've been a decorated officer, isn't that right?
Yes.
There's never been any type of blemish on your record or history, is there?
There has not.
And it was not your intention in any way, shape, or form to mislead any member of the grand jury, was there?
Absolutely not.
And it's not your intention to mislead any member of this trial jury today, is it?
No.
And all of your testimony today has been truthful.
Yes, it has.
Your record is unblemished and unbesmirched, is that correct?
Yes, sir.
Now, defense counsel is leaving the impression that the state has somehow railroaded the defendant concerning the grand jury.
I think that misstates my direct examination.
That's not a question, please. Mr. Byers. Restate a question without the opinions and editorializing.
I'll restate the question, Your Honor. Defense counsel asked you a series of questions saying that once the decision to charge has been made, it's hard to stop that, isn't it? Didn't he ask you that?
Yes.
Okay. Now, you've been a detective for how long?
Approximately 9 years.
And you've been an officer for how long?
7 years. A total of 16 years.
Total of 16 years. Now, in that time, You've had occasion to bring cases to the attention of the district attorney and requested it be dismissed, isn't that correct?
Correct.
Matter of fact, you've known, I'm not going to testify. So then it is not true that the process, once a person has been charged, cannot be undone. The process can be changed, isn't that right? You have done it.
Yes, sir.
Now, the function of the grand jury is to find probable cause, isn't that right?
Yes, sir.
The function of a trial jury is to determine guilt or not guilty. Is that correct?
Correct.
And issues of self-defense are not something that is within the province of the grand jury, isn't that right?
Correct.
What is it, like, under the rules of evidence, what's your objection?
Improper.
Overruled.
The issues of self-defense are not something that's within the province of the grand jury, isn't that right?
Correct.
They're just there to determine whether or not there's enough evidence to find probable cause that the case should go to trial. Who's the attorney on this for the defense, Your Honor?
Mr. Clark, do you wish to approach?
This is the next question.
Well, it's the question that's being asked. Go ahead and restate it.
I think I forgot the question, actually.
It's related to the probable cause and the role of the grand jury.
Thank you, Your Honor. The role of the grand jury is to find probable cause, isn't that right?
That's correct.
Okay.
All right, go on to your next question.
Thank you. You identified yourself as the case agent for this case, right?
That is correct.
You said that you got there about 2 o'clock in the morning. At that time, Lieutenant Kerry Clements, who's already testified, was the lieutenant in charge of the homicide unit, isn't that right?
That's correct.
And he was getting ready to retire, and he was going to be replaced by then Sergeant Casey Mullins, isn't that right?
That's correct.
And their detectives, Porras and, Martinez and Bardwell, they participated in collecting evidence in this case?
Yes.
Detective Torres, who testified, participated in collecting evidence in this case?
Yes.
There were a number of detectives and sergeants associated with this investigation, isn't that right?
That's correct.
But you're the case agent. Is it possible, is it somehow possible that one of those other detectives who may have interviewed a witness may not have passed that information to you at a particular time?
It is possible.
Now, Mr. Clark asked you some questions about this blanket. I'll call it a comforter. The item, which has been shown repeatedly with a large amount of blood. And just for example, so we know what we're talking about, this comforter here shown in Defense Exhibit 68, particularly pointing to this area where there appears to be some red-brown staining. Now, you can describe for the jury the method whereby items that are that you want to get tested for DNA are submitted to the lab. You can describe that, can't you?
Correct.
Please do so.
When I submit for a DNA code through the New Mexico lab, I itemize several items from the evidence list that I want tested for DNA. I name several items on that form. The response back from the New Mexico State Lab is that they will only take a certain amount of items. Sometimes it's, depending on the case, on this particular case, they asked me to send 10 items up at the beginning, but I was able to send up additional items at a later time, and I did not.
Now, that threshold item of 10, that has recently changed, hasn't it?
Excuse me?
The threshold item, the amount of items that you could send at one time that was 10 whenever you submitted these to the lab, it's now changed to a lower number, hasn't it?
Correct.
What's that number?
No, the original number that I had itemized was more than 10.
Uh-huh.
I don't recall the exact number.
Okay, so you itemized more than 10, you sent them up to the lab, right? And they only accepted 10?
They only accept, the process is that fill out a form of a DNA code. I email it to the Santa Fe lab for an acceptance code. They will in return, they will tell me, or they will call me, it's telephonic at times, and they will tell me, we don't need this, send this, and that's how the itemized list is cut down. So if I wanted to send every single item that I had requested to send, they did not accept that at the first time that I submitted evidence into the lab.
So if they don't accept it, you really don't have much control over it, right?
I do.
You can turn around and resend it and resend it and resend
Yes,
it.
I can send items up in a different group. I do.
Now, in this particular case, you had completed your requirement to send items to the lab, right?
Correct.
And they did not accept some, or they were not going to accept a certain number for testing in the first batch. Am I understanding you right?
Correct. It's not that they don't accept it, it's the amount that they're accepting at a time. Because of their caseload up there, they ask us to limit our items, and then we can resubmit at a later time.
Okay. Showing you this reddish-brown stain on State's Exhibit 68, which is on the comforter, and there's been testimony that has been tested. It was sent up to the lab after Raman Sandhu Karmer, the DNA analyst, testified, right?
Correct.
Okay. Now, when she testified, and correction, whenever that was sent up to the lab, did you know whose blood was on that comforter?
I did not.
Did anybody representing the state know whose blood was definitively on that comforter?
No.
It could have come back to be Jeremy Martin's, right?
It could have.
It could have been anybody's, right?
Yes.
But in an effort to be transparent, it was sent and analyzed. Is that correct?
That is correct.
And the result came back showing what?
That it was Tai Chan's blood.
And that is consistent with all of the other evidence that is associated with that particular geographic location inside that room. Isn't that right?
That is correct.
That's what we've been saying all along, isn't it?
Yes, sir.
Now, Mr. Clark had made a statement concerning your observations about whether or not a struggle had occurred. He mentioned something about shoes and pillows on the floor. Just from shoes and pillows being on the floor, is that alone enough to determine whether or not a struggle had occurred?
No, sir.
So then it's fair to say that you took a totality of the circumstances look and figured in some other things like what appeared to be blood, right?
Correct.
And what appeared to be bullet holes in the walls, right?
Correct.
And to get to the bullet holes in the walls, you had to walk past shell casings in the hallway, isn't that right?
That's correct.
Now, Mr. Clark said that your decision to charge the defendant with murder, was just based on DNA test results.
I believe that misstates facts.
I'm sorry, I didn't hear you.
I believe that misstates what the question was.
If it does, then I'll let the witness correct. What is the question that you're asking?
I'm sorry, Your Honor. The question that I was asking was that Mr. Clark had stated that the decision to charge the defendant with murder was based on, was before DNA test results. Can't read my own writing.
I'm sorry, you're asking that as a question for confirmation from the witness?
I am, Your Honor. And I'll repeat the question.
Yes, please, because I think it's confusing.
On direct examination, Defense Attorney Clark said that the decision to charge the defendant with murder was made before DNA test results were obtained.
Correct.
And that is true, isn't it?
Correct.
And you participated in that determination to charge the defendant with murder, isn't that right?
Yes.
Now, previously I'd mentioned a number of other detectives who had worked in support of you on this case, isn't that right?
Yes.
And isn't it part of the normal policy and protocol of the Las Cruces Police Department to basically get the opinion of other detectives on the quality of the evidence, the veracity of the evidence, to try to arrive at what would be an appropriate charge?
Yes.
Did that happen in this case?
Yes, it did.
There were some other things that your decision and the decision of the Las Cruces Police Department and the decision of the District Attorney's Office to develop this charge was also informed by forensics that were collected at the scene, isn't that right?
Correct.
Also informed by eyewitness testimony, isn't that right?
Correct.
Mr. Clark had made a comment, correction, he had, as he was conducting his direct examination, he had mentioned that the defendant had said, as it was copied on the recording introduced through Officer Cosper, that Mr. Martin had shot at him first. Isn't that right?
That's correct.
Now, you have been to a number of crime scenes, isn't that correct?
Yes.
In this case, it's fair to say that everything associated with Defendant Chan was over on the side of the room that was closest to the bathroom, isn't that right?
That's correct.
Everything associated with Jeremy Martin was over on the other side of the room near the window, isn't that correct?
Yes, it was.
On the table near the window, identified by marker M, is Jeremy Martin's blue bag, right?
Yes.
Inside that bag, when you got there, there was 2 firearms, right?
That's correct.
Both of them were holstered, right?
Yes.
And neither of them was tested for DNA, isn't that right?
They were not.
Okay. Explain to the jury, well, let me back up before I do that. When you were looking at the crime scene and listening to the statements of the ear witnesses and listening to Leah Tafoya, who had the open line, did it seem reasonable that Jeremy Martin would have used one of his weapons to somehow assault Defendant Chan?
Judge, I would reject that calls for speculation.
If she knows, Your Honor.
If you know.
Could you repeat the question?
Sure. Given the fact that the bag containing Deputy Martin's his duty weapon and his backup sidearm were holstered inside a blue tote bag, is it reasonable that he would have somehow had either one of those firearms and been threatening or assaulting Defendant Chan with it?
No.
Because the timelines wouldn't match up, would it?
Correct.
Wouldn't make sense for somebody to threaten somebody with their own gun and then put it away and zip the bag and holster it, would it?
Correct.
And it also wouldn't make sense for Jeremy Martin to pull defendant's firearm out of his bag, would it?
No, it would not.
Everything associated with Jeremy Martin inside that room indicated that his weapons were safe and in a secure place. Isn't that correct?
That is correct.
Now, Mr. Clark mentioned the bagged hands of Jeremy Martin's body whenever it was sent to the Office of the Medical Investigator for autopsy. And That is to preserve evidence, isn't that right?
That's correct.
And he mentioned something about whether or not fingernail clippings were preserved for DNA testing, isn't that correct?
Yes.
Okay. Now, you saw the photographs of Defendant Chan that were submitted into evidence, right?
Yes, I
And
did.
you saw them long before they were admitted into evidence before this jury, isn't that right?
Yes, I did.
And those scratches seem to be fairly light and superficial, isn't that correct?
Yes.
Have no idea what could have created them, isn't that right?
I do not.
Now, Mr. Clark also asked you questions about swabbing Jeremy Martin's hands, gunshot residue. You're the case agent. You were permitted to remain inside the courtroom and hear the testimony of forensic firearm expert Steve Guerra, right?
Yes.
You actually heard defendant's attorney Clark praise Mr. Guerra as being one of the premier firearm and tool mark experts in the state, right?
Yes.
Mr. Guerra also testified from that witness stand right there that you're sitting at right now that gunshot residue tests haven't been done in this state for well over a decade. Isn't that right?
Yes.
So it is absolutely incorrect whenever Mr. Clark says that that test was available to you and the Las Cruces Police Department to use to swab Jeremy Martin's hands. Isn't that correct?
Yes.
There's some other little factor. You heard the testimony of Connie Hurd, and she said that he was covered in blood. Isn't that right?
Yes.
You heard the testimony, the audio of Sergeant Froats whenever he had helped her put Jeremy Martin into the back of the police unit. And he's cursing and he's asking for some type of hand cleaner because he says he's got blood all over him, right?
Yes.
You've seen the photographs of the inside of the elevator. Copious amounts of blood were lost, correct?
Yes.
In your training and experience, it is quite possible that if there would have been a test available for gunshot residue, notwithstanding that, the amount of blood that was involved in the death of Jeremy Martin could have very likely washed away any type of residual evidence associated with any gunshot residue, correct?
Correct.
Mr. Clark identified some times. 11:56, a phone call between the defendant and Leah Tafoya. He said that she kept a line open. She testified to that, right?
Yes, she did.
Okay. Now, he also mentioned that that doesn't have anything to do with what went on in the room, right? It doesn't tell us anything about, the timeline does not narrow down for us what actually happened between either of these two people inside the room, does it?
No, it does not.
There was a question on direct examination about video surveillance that was associated with Mr. Clark's questions to you concerning the timeline. You've seen that video surveillance, right?
Yes, sir.
In one of those images, it shows the defendant walking through the seat of the camera with a cell phone to his ear, doesn't it?
Yes, it does.
Doesn't seem like he's stumbling, does it?
No, it does not.
Just walking with a cell phone to his ear. Like normal, right?
Yes.
May I have a moment, Troy?
Yes, go ahead.
Pass the witness, Your Honor.
Thank you. Mr. Clark, redirect examination of the witness.
Thank you.
Detective Palos, is your job to speculate about things?
No, it is not.
No. Is your job to collect evidence?
Yes, sir, it is.
Is it your job to do?
Objection, leading.
In this case, this is your witness, giving you a lot of latitude.
I'll rephrase the question, Judge.
But again, let's understand that we have to move things along a little bit. It helps to allow some degree of leading at this point because we're not covering any new ground.
Is
So
it?
I'm going to sustain the objection and ask you to be very careful in terms of how you phrase your questions.
Is it your job to collect evidence?
Yes, sir, it is.
And is it part of your duties to make sure that everything that can be tested, needs to be tested, is done? Right?
Yes, it is.
Now, when I asked you a moment ago about a test for gunpowder, I wasn't asking you a trick question, was I?
No, sir.
I think I believe the question was very clear. Is there a test that can determine whether or not someone fired a gun, right?
Correct.
And I believe your answer to a very straightforward question was in the affirmative, yes, right?
Yes, sir.
And maybe I misunderstood, but when Mr. Byers asked you, you told him that even though the test exists, you don't use it? Is there a test? So I'll ask the question. Is there a test to determine whether or not you can determine whether somebody's fired a handgun or a weapon?
Yes, sir.
And that's available to you and it's at your disposal, right?
I have never used it.
But it's available to you.
I believe so.
And Detective, when I asked you a moment ago whether your job is to speculate, you answered no, right?
Correct.
And so when Mr. Byers asked you to speculate what took place in the hotel room that night, you don't know, you weren't there, right?
That's correct.
And that's why you have all these tools at your disposal to determine the facts, collect evidence, and then perhaps a trier of fact will make that determination of what happened, right?
Correct.
So, is it normal for you to speculate in your job? Speculate as to what happens in any case?
No, sir.
No, you just collect the evidence and build your case, right?
Correct.
And that's what you were asked to do in this case.
Yes, sir.
Pass the witness.
Thank you. Is there any recross examination?
There is, Your
Mr.
Honor.
Byers.
Yes, sir. Two issues, Detective Paulus. First, Mr. Clark said that it's your job to collect the evidence, right?
Yes.
You answered in the affirmative, correct?
Yes,
You're the case agent. You're ultimately responsible, right?
I am.
And in order to, do you have a ballpark figure for how many items of evidence were collected in this case?
Over 100?
Would it be over 200,
Yes, over 200.
including documents and audios and videos,
Yes, that's correct.
DNA, firearm?
Yes, sir.
And you've been present for the admission of all of the evidence in this case in the trial, right?
That's correct.
And in order to collate all of that evidence, you have to depend on other detectives, right?
Yes,
You even have to depend on very specialized people like Jerry Barreras and Max Weir, right?
yes,
Now, Mr. Clark asked you about gunshot residue testing. And he narrowed down the question, said, is there a gunshot residue test available to you? Your response was, you said you don't use it, right?
correct.
Now, you heard the premier firearm and tool mart guy from the state crime lab say that they don't do it. They do not perform the test. So it's reasonable to believe that even if you requested the test, they would not do it, right?
That's correct.
Now, have you ever, in your 16 years of law enforcement experience, sent a firearm from Doñana County to any other lab besides the New Mexico State Crime Lab to have it tested for gunshot residue?
I have not.
No further questions.
Thank you, Mr. Byers. Does the jury have any questions of Detective Paulus? Detective Pavlos, the jury has some questions of you. And again, I caution you, don't speculate and respond if you know the answer. How many items of evidence were sent to the New Mexico Crime Lab for testing? How many actually went out?
I would have to refer to the list. I don't have an exact number for you.
Is the list readily available to you?
Yes, sir. They should have it.
Let Mr. Rourke or Mr. Byers, let the witness review that list in order to respond to the question. Detective Pavlos, if you know where the document is, why don't you retrieve it? That way there may be some confusion. The counsel can take. Retrieve the item, that's all you have to do. Please review it and see if you're able to determine from the report the number of items that were sent to the lab for testing.
On this,
Let me ask you first, is this a listing or a document that you prepared?
no, sir, it is the laboratory report of the DNA results. I don't have the list that I prepared.
So you don't know how many items you actually sent out?
I do not. I do not
Does
know.
that tell you how many items were sent? Because the next natural question is, how many of them were tested?
This is going to be how many were tested.
Okay, so how many does that report indicate? How many items, different items were tested? What is the total number?
So 20 items?
And to your knowledge, or the best of your recollection, do you have an amount that was actually sent up to be tested?
I do not have an amount. I do not recall the total amount.
Okay. Were there items that were not tested that were sent to the crime?
No, if I sent an item, it will be tested.
And it's a discussion in terms of you ask for a consultation with the lab in order to determine what items will be sent.
Correct.
And it's then by agreement, the number of items and the specific items that will be sent.
Yes, sir.
Does the police department or the district attorney's office decide what charges to file against the suspect?
I'm sorry, could you repeat the question?
Does the police department, and again, I'm narrowing it down to those that are involved, or the district attorney's office decide what charges will be filed against the suspect?
It is the police department. We do speak with the district attorney's office in reference to the charges, but it is our decision of what is charged.
So your response is basically, ultimately, it's the law enforcement authorities who make a final determination as to the charges themselves.
That is correct.
Was Mr. Chan's duffel bag found open or closed?
It was opened.
Was Mr. Chan's weapon, or the holster to the weapon recovered? Answer that question first.
Yes.
Was it on or off his person?
It was off his person,
So where was it located?
inside his duffel bag.
Were there any other weapons that were found that belonged to Mr. Chan or what were in his possession?
No, sir.
Was there any blood found on the phone that had the red case and that was depicted to you during your, I believe, your direct examination?
It did have a red substance on it, but it was not tested for blood.
And again, this is a question that I want you to be careful with and not speculate on. But a shell casing was found by the bed closest to the window. I believe this to be in room 711. Where would the pistol that was fired, where would the pistol have to have been located at the time that it was fired in order for the shell casing to be found in the position that it was located?
I do not have an answer for that.
Again, the question is there a standard operating procedure for collecting samples of evidence? And then again, this is by the investigating officers. Is it a department-wide policy, and is there a checklist?
There's not a checklist. The items that are recovered for evidence are per the discretion of which would be me, the case agent, during the processing of the scene.
The question goes a little bit further, but I'm not clear to what specifically. What is the basis for leaving some objects out? I'm not clear if that means related to the testing of items. Why would there be a reason that some matters are tested and others are not? Some items are tested and some are not.
It depends what items you're asking about. There's
the items that, of course, that we've been hearing all of the testimony related to. One, why were some tested? Why were some not?
right. In reference to the firearms belonging to Jeremy Martin, those were not tested because all the casings were recovered and tested, and the projectiles tested all came back to belonging to Tai Chan's weapon. So therefore, Mr. Martin's handguns that were in his bag that was sealed inside the room and never left the holster, I did not have those tested.
Again, just so that I can cover this question completely so that another question doesn't have to come forward. Were there any items of what could be perceived as evidence that were left out of your listing or compilation of items and evidence?
No.
Is there a standard operating procedure to report all communications to the detective in charge as part of the protocol or chain of command?
We do communicate with each other, but we're at different places at different times throughout the investigation, so it doesn't always happen exactly how it should happen. But yes, there is communication throughout the entire crime scene investigation, or through the entire investigation.
So that you're responding to the question. The question is there a standard operating procedure? Is there your training manual or the manual that you follow during the steps involved in an investigation? Is there a specific direction or procedure in terms of how the communications occur with the detective in charge?
Yes, there is.
And just briefly, will you describe what it is to the jury?
The communication for it starts with the supervisors that are on scene with, if I'm understanding correctly, The supervisors on scene, myself as the lead detective will report anything that I need to report to them. As I am gathering information, it is being related to the supervisors. In turn, they are relating information to myself. Other detectives are sending information to the case agent, which is myself, and also through supervisors. But usually it goes to the case agent, from the detectives to the case agent, from myself, anything that I feel needs to be reported immediately to the supervisors, that will go directly to them. So there's information going back and forth throughout the entire time.
So if there is a standard procedure, what would be the basis or the purpose for not following the procedure?
I don't understand.
Why would someone not follow the procedure if there is an established procedure? You indicated in some of your earlier testimony that sometimes it doesn't work.
Correct. It just depends. I can't speak for other detectives. There's a lot going on in an investigation. It's not purposely withheld. It's just sometimes you don't get the information that day. They may tell you the next day or the following. It just depends. There is a procedure, but I really don't know how to explain that, other than it should be followed, but sometimes it is not.
Does the jury have any additional questions of this witness? Again, I'm not going to ask for you to be the excuse sincerely case agent here, but thank you very much for your testimony.
Your Honor, there's a house cleaning issue regarding one exhibit, the state's exhibit that hasn't been used as evidence. And we'll go through it.
Yes, go ahead. You may want to proceed with calling your witnesses. Again, since this is your witness, Mr. Clark, go ahead and proceed.
Detective Powell, oh, I'm sorry. Detective Powell, there's been extensive testimony about this dust ruffle, or the comforter.
That's
I
correct.
believe that this is the comforter.
Yes, it is. This photograph is a fair and accurate representation of that comforter.
Yes, it is.
So, Your Honor, the defense would move the comforter as defendant 63.
Right. And again, this is a photograph, this is a prior exhibit that was admitted into evidence. It is a photograph of the comforter that there's already been testimony to that it is blood that was contained on the comforter and the blood belonged to the defendant by chance. The court is, for the record, using this exhibit to create defense exhibit number 63.
63, Judge.
And defense exhibit number 63 will be the actual comforter that will be admitted into evidence and available to the jury during their deliberation along with all of the other exhibits.
Okay, thank you. And Detective Powell, I'm showing you 33, defendant's 33, which is exhibiting the dust ruffles I've talked about.
Yes, sir.
And does the photograph present a fair and accurate representation of the article of evidence you actually took into your possession?
Yes, sir.
So, Your Honor, I would use Exhibit 33 as a photograph to move the actual dust ruffle into evidence as defendant's 64.
Again, the court is going to admit into evidence, since the court is aware that there is no objection, to defense exhibit number 64. Number 64 will be the actual item physically that will be admitted into evidence and be made available to the jury during the course of their deliberations in this matter. Anything else?
Nothing further, Your Honor. Thank you for your indulgence.
Detective Paulos, thank you very much for your testimony. You return to your chair. Mr. Clark or Mr. Day, who will your next witness be?
Next witness for the defense will be Josh Sexhauer.
Why don't you make them available to the court, that we're going to take a short recess at this time, approximately 10 minutes, and then we'll return for continued testimony.
Please rise, jury.